Good evening, everyone. I just want to thank again Ben Patton, QC, and Tom Owen for organising this and bearing with me quite patiently. I'm going to move on to the definitions and legalese in a moment, but this is an issue that does not have a clear linear answer or a legal answer, and the answers or the way forward involves collaboration and some imagination. And I thought it'd be useful maybe to start with the idea of the radical imagination, which is a term I find very comforting. And one definition of it is that the radical imagination is the ability to imagine the world, life, and social institutions not as they are, but as they might otherwise be. It is the courage and the intelligence to recognize that the world can and should be changed. It represents our capacity to imagine and make common cause with the experiences of other people, and undergirds our ability to build solidarity across boundaries and borders, real or imagined. And particularly poignantly, without the radical imagination, we are left only with the residual dreams of the powerful. And for the vast majority, they're experienced not as dreams, but as nightmares of insecurity, precarity, violence, and helplessness. And without it, we are lost. So just want to bear in mind the idea of imagination as I'm going through this talk. Just starting off then, the legal lecture properly, with some definitions. So modern slavery, it's an umbrella term that covers various terminologies, broadly covering slavery, what we understand as forced and bonded labour, human trafficking. And there's a helpful definition in the Global Slavery Index, which defines modern slavery as situations of exploitation that a person cannot refuse or leave because of threats, violence, coercion, abuse of power, or deception. There's also a helpful definition of forced labour by the International Labour Organization, ILO, and I'm going to be referring quite extensively to some of their work, as all work or service which is exacted from any person under the menace of any penalty, and for which the said person has not offered themselves voluntarily. There's also the concept of bonded labour or debt bondage, which is the status or condition where a person has pledged their labour or service, where the fair value of that labour or service is not reasonably applied. As security for a debt, where the fair value of that labour or service is not reasonably applied towards the liquidation of the debt. That means that the person is tricked and trapped into working for very little or no pay. And the debt is often a loan provided to cover the recruitment fee and travel to take up the role. This is particularly apposite to the abuse of migrant workers in construction projects. We also have the European Convention on Human Rights, which Article 4 says that no one shall be held in slavery or servitude, and no one shall be required to perform forced or compulsory labour. Perhaps sensibly, there's no definition of slavery or servitude in the convention itself, or indeed of forced or compulsory labour, but it excludes from the definition military service, civic service requirements in various European countries, having to work in prison and so on. So there isn't actually a known working definition of what slavery or forced labour comprise under European law, under the convention. And likewise, there's no definition, unhelpfully, in the UK Modern Slavery Act 2015. It does say that the understanding of slavery will take into account Article 4 of the Convention, which again does not contain a definition. It just excludes certain things from slavery. It also prohibits human trafficking, which is defined as arranging or facilitating the travel of a person with a view to the person being exploited. And the definition of exploited includes securing services by force, threats, or deception. So that would, to my understanding, include forcing someone to work without proper pay or without the pay that was promised to them. So looking at the construction sector and its vulnerability to worker exploitation, and particularly migrant worker exploitation, although it's difficult to get an accurate count of the number of workers in the construction sector, the Building and Woodworkers International Guild estimated that there were 180 million workers in construction in 2006. And it's also of note that the sector employs some of the most vulnerable people, including those who are uneducated, illiterate, without formal training, and includes the landless poor and a large number of rural to urban migrants, people who are not used to living in cities. In 2012, the ILO estimated that there were 20.9 million people in forced labor globally. And just to understand the gendered impact of this, the majority of these were women and girls. 11.4 million, 9.5 million of them were men and boys. And the figure included 14.2 million people, 68% in the private economy sectors, such as construction, manufacturing, mining, utilities, agriculture, forestry, fishing, and private domestic work. And construction was a large, unfortunately, a large player in the forced labor estimates. The 2017 global estimates of modern slavery and child labor estimated that 18% of adults subject to forced labor in the private economy are employed in the construction sector. And that was only second to domestic work in any other field of activity. In terms of the construction sector generally, it's helpful to look at what drives migrants to construction work and what other particular vulnerabilities that arise there. Construction, as we know, is big business. It accounted in a 2015 survey for roughly 13% of GDP, and that figure was forecast to grow by 2020 to 15%. We don't quite know what the impact of COVID was, and growth might have slowed, but it's certainly a key sector worldwide. Again, in terms of value, the construction market was projected to grow to $12 trillion by 2020, with most of the growth coming from the United States, India, and China. And the face of construction is changing. Countries in what's proverbially called the Global South, which includes the UAE, India, China, Brazil, now account for the majority of construction activity. They accounted for 52% of construction activity by value in 2015, with China having overtaken the United States to become the largest construction market in the world. And that share of industrializing countries in the Global South was expected to grow to 63% of the global market by 2025. As I mentioned, it's estimated 180 million people employed by the construction sector. In terms of the kind of the driving forces behind the increased activity in the construction market, these tend to be government infrastructure spending plans, general economic growth and urbanization, the rapid rise of cities and people moving there. An important aspect of modern construction activity, which is relevant to the issue that we're looking at, is that it is becoming increasingly international. So multinational firms are expanding globally into new markets, and that means that the really big firms with $1 billion in turnover or more. And there has also been regional multinationals arising in the recent past, and we know some of these, for example, from our work in the Gulf and in East Asia. So you have Samsung, Hyundai, and Emaar in the Gulf. And the trend is for construction to become more and more of an oligopolistic market with some very dominant multinational firms, which again could have a resonance in looking at the kind of way forward in terms of impacting change, because some players or a small number of very large players can have a disproportionate impact on workers' rights. the reasons for these, very briefly, are related partially to changes in the approaches to construction, streamlining the production process, which meant that relationships with the supply chain, manufacturers, investors, etc., can really make a difference in terms of the capital and the prices available to bigger actors, allowing them to drive out smaller companies and have much more access to market share. It's also a industry where, despite technological advances, it's a very labor-intensive process. So labor costs are a major part of the overall cost of construction. And with the rise of multinational construction firms, we've seen a closely linked rise of migrant labor. So some firms actually have a business model where they go to new territories but bring in their labor as migrants as part of the contracting deal. And this has actually allowed them to post migrant workers, that's the expression, to the project and really undercut maybe some of the European and American firms which don't have that labor model. And that's actually meant that some of the Western firms have now kind of changed their operating models and moved away from actually offering the construction work overseas to just focusing on design and construction management contracts. Another important aspect of construction, which is really important to assessing migrant welfare and human rights in the construction trade, is the rising importance of subcontracting. Subcontracting has always been important in construction because of specialisms in trades, but there is evidence to suggest that there has been an increase in subcontracting practice over the since the 1980s. And many companies, as I've said before, are getting rid of core workers, core skilled workers, and relying on outsourcing labor and outsourcing subcontracting. And that is also compounded by the fact that a lot of the work involves quite specialized services. So you then have a longer chain of subcontractors and suppliers. And subcontracting is something that really does have an impact on worker welfare and regulation of worker welfare, because the longer the chain, the more difficult it is to track activity or accountability. It also creates some confusion as to who actually is responsible for various welfare schemes and benefits for workers that may be required under regulations. And it also creates a trickle down. So each part of the supply chain awaits wages coming down the supply chain. So the employer pays the main contractor. The main contractor is not paid, then the subcontractor is not paid, and so on. It can also create a fragmented workforce. So you'll have people on the same site that have quite vastly different benefit schemes, wages, and so on, and protections. Also, subcontracting, and I'll talk about this in a moment, means that the recruitment of workers becomes multi-layered. So each part of the supply chain is responsible for its own recruitment. And one of the key vulnerabilities for migrant workers is the recruitment process, which often involves hidden fees and possible debt bondage. So again, subcontracting in the construction industry is a fact, but it's also a fact that makes it particularly vulnerable to worker abuse. Another fact is, and I think many of us are beginning to realize this, is that construction projects have low profit margins in many parts of the world and are particularly cost sensitive. And I put here a quote from the Business and Human Rights Resource Center. And it's worth kind of looking at that. Given that profit margins in construction are extremely low, least cost procurement puts enormous pressure on contractors to underprice their work in order to secure business and maintain profits. Raw material costs are generally fixed, and consequently, companies minimize expenses by cutting labor costs. to the detriment of workers' pay and the quality of their working and living conditions. Construction contracts are awarded on a short-term basis, putting pressure on companies to deliver projects in an allotted time frame. This pressure creates little incentive for companies to invest in workers' rights and implement good practices. So it's really the nature of the beast in many cases that the contracts have very little room for profit. And one of the easiest ways to cut costs, especially in an unregulated economy, or unregulated in terms of workers' rights, is to cut back on worker protections. But it's also vulnerable to having to do a lot of work in very little time. So there's immense pressure on the employers or contractors to really get workers working, sometimes at the expense of their well-being. So that's a look at the construction industry and some of the kind of structural issues that make it vulnerable to worker exploitation. And then looking at migration in the context of the construction sector. Migrants, both temporary and permanent, have long been a fact in the construction markets in many countries. For example, we have the historic example of Chinese people being brought to America to build the railroads a couple of centuries ago, and many colonial subjects being moved to odd parts of the world where you wouldn't expect to have found them, for instance, Indians to the Caribbean and so forth. So it's quite a common occurrence. And that's not mentioning, of course, the slave trade, which I wouldn't be so insensitive as to include with migrants, but the fact is people have been moved and exploited to build things for many years throughout history. The sector's heavy reliance currently on migrant labour is often due to a number of factors. One obviously is the spatial fact of construction. You can't move the project to where the workers are. You've got to move the workers to where the project is. It's, as I mentioned before, a highly labour-intensive sector in which you need a lot of people on the ground, especially in less industrialised countries where they have less technical means of working. And also, immigrants and temporary migrants employed in the trades have often been important to construction because they do jobs that no one else wants to do. A great deal of construction has long been and continues to be considered dirty or dangerous or poorly paid work, and it has a low status. There's also the fact is that the use of migrant workers, with the increase in multinational work and the increase in urbanization, has increased considerably in the last several decades, and it's a trend that's expected to continue. The obvious example is the Gulf, where you see many of us who visited will see almost a parallel population of migrant workers working essentially in construction. Singapore also has an estimated 160,000 migrants from South and Southeast Asia. The UK is less pronounced, but it's still significant. According to the CITB report in 2017, about 12.5% of the 2.1 million adults working in construction in the UK were born outside of the UK. Around 45% of them were from the EU accession countries. So the ILO report in 2016 identified three broad factors in driving construction employers to increasingly look outside national borders for workers. The first is that in industrialized economies, they have aging populations, underpopulations, and falling birth rates, the demise of people taking up trades has produced a structural shortage of construction labor. That's less of an issue in the industrializing nations, but there it's just simply the fact that the demand for construction in terms of housing, office space, infrastructure just has outstripped the availability of local construction laborers. And then obviously there is the issue of just the scale of projects where a huge mass of people is needed in a short space of time for for example, build a high-rise or build an ambitious infrastructure project. So that's really three key reasons why there continues to be heavier reliance on migrant labour to assist the construction sector. What we also noticed is that with the movement of peoples, it often leads to segmentation in the labour market, in which the newly arrived migrant workers who may have precarious residency rights or may indeed be illegal workers have different wage entries compared to the existing resident population. And in fact, in countries like the UAE, where there's very little regulation on wage control, I think recently Qatar has, in response to the World Cup fiascos, has introduced a minimum wage. It's quite common to have wage hierarchies based on gender or ethnicity. So it's quite common, for example, to have on the same site, working for the same contractor, a different rate paid to Nepali workers, a different rate paid to Pakistani workers, and so on. It's considered unremarkable. And you do get these informal and informal ethnically or nationally based divides, perhaps more subtly in other countries as well, in the developed world. An example, I'm just conscious of time. An example is of a strike in the UK in 2009 at the Lindsey Oil Refinery in North Lincolnshire. So there is in place a European Posted Workers Directive, which is intended to make sure the migrant workers are paid the same as national citizens. However, the UK government reads that as meaning that the migrant workers have to be paid the minimum statutory pay and benefits, but doesn't take into account any collective bargaining that local workers may have achieved. And this led to strikes in the UK, for instance, 2009, when 300 posted workers from Italy and Portugal were brought to a desulfurization unit on the Lindsey Oil Refinery. And there were strikes and walkouts and wildcat strikes with accusations that the contractor was violating the essentially the nationally agreed benefits and paying the migrant workers on inferior terms, which meant that the local workers were at a competitive disadvantage. And to be fair, from my reading of this wasn't, as one would suspect, antipathy to the fact that these were migrant workers. It was perhaps a justified view that the wages were being brought down because the migrant workers weren't being treated equally or given equal benefits. So I just want to look at particular risks in the migration process, or particular risks to migrant workers in the construction industry. And one of these arises from the migration process itself. And debts are a defining feature of the international migration process for many workers in the construction sector. So what typically happens is that they are approached by recruitment agencies saying, we can land you a job in the Gulf or wherever, but you'll have to pay us a fee. The fee is quite high to begin with because these are landless people. They don't have necessarily any source of income typically. So this is speaking in very general terms about the most vulnerable people and recognizing that there is a wide variety of immigrants and reasons for migration. This is purely looking at some problem areas. So you get approached by a recruitment agent saying you'll have to pay me X amount, which is quite high to begin with. That's suggested to a landless person who's now seeing this as a way out of poverty to provide perhaps for quite a large family. They don't have the recruitment fee to begin with, so they can't go to a bank because they don't have any collateral. So they then go to a money lender, an informal money lender, to pay the recruitment fee. That informal money lender will charge them interest at an extremely exorbitant rate. This is all in the black economy. So there's a huge amount of debt that's already been incurred before the migrant actually even lands the job. And these recruitment fees do can become a a cycle of debt and possibly a form of debt bondage, both to the persons to whom the debt is owed, but also to the employer. The migrant can't afford to leave the job no matter what happens, because he or she will then have to face the debt and the consequences of that debt. Now, there have been moves formally to try and counter this cycle of debt. And this is a key issue for many migrant workers, certainly in the Gulf region and in developing economies. So, for example, UAE law prohibits employers from working with agencies that charge recruitment fees, but the practice is still endemic to the construction sector. In preparing this talk, I spoke to a few people working in the field, and what they generally told me is that when you're at the top level, when you're looking at the main contractors or even one level below, they tend to have quite good due diligence. They tend to have quite good relations with recruitment agents. But the difficulty is that they only recruit a small proportion of the workers on the site. Most of the workers are brought in by the subcontractors, and it's very difficult, or they find it difficult to find the resources to oversee those people, and that's where the exploitation comes in. So, for example, there's also a disconnect between the countries of origin and the countries of destination. So all of the UAE prohibits employers from working with agencies that charge recruitment fees. Indian law allows some grades of recruitment fees, which are generally reasonable. But the fact is that most of the vulnerable workers wouldn't go to the registered companies. They'll go to informal recruitment agencies and informal money lenders and end up in these cycles of debt. And that's then makes them more vulnerable to staying in an abusive workplace, but also that the debt becomes compounded if they're not paid properly. Just looking at the kind of the answers to this, there's an interesting, a valuable report by the BSR, which is a Business Sustainability and Research Institute in 2016, and it looked at the difficulties caused by this endemic problem of debt and recruitment fees. And it said, in its current form, recruitment of migrant workers sometimes involves bilateral agreements between sending and receiving countries that cover the main conditions under which workers can be recruited. However, even when they exist, these agreements are difficult to enforce, and there are many intermediaries from both the origin and the destination countries who require payment from workers to help facilitate the migration process, and are willing to abuse workers by, for example, extorting exorbitant fees. Individual companies can change their practices by either moving towards a more direct recruitment process or a fully employer-paid recruitment process. The impact of such changes will remain limited, and companies that adopt these changes will run the risk of not being able to compete on costs against companies that are still relying on workers willing to pay for their recruitment. That is actually where the radical imagination comes in, maybe. I mean, it's quite clear that if one company were to suddenly say, well, actually, we're going to take the time to manage the recruitment process, we're going to put in the kind of the measures to do that, then their costs of running the contract will go up, and there probably won't be the company getting the contract, and it'll be won't be a very effective move. And that's where the BSR recommended that a group of committed companies could meaningfully engage both sending and receiving governments as well as the recruitment industry to make the case for the development and implementation of better practices. So what this really requires is collaboration between the big players, at least, to get to have some effect. And I'll be looking at that in a moment. Another risk in the migration process is the lack of information. It's a very asymmetrical process. You know, a young labourer in, let's say, in Pakistan or Nepal or Bangladesh is going to have very limited, especially a rural worker, is going to have very limited knowledge of what moving to the UAE involves, what kind of jobs are available, what their rights are. Whereas the recruitment agent has all the information on the worker and their vulnerabilities and what their other options are. The status of just being a migrant carries with it vulnerabilities. So the fact that the migrant it has a limited immigration status, and I'll be looking at the kafala system in the UAE specifically, but the fact that their ability to reside in the country may depend on staying with their employer or keeping their employer happy, is obviously a vulnerability in itself. Many of the recipient countries, which are particularly problematic, do not allow migrants to enter into collective bargaining agreements or unions of any form. They're prohibited. And they also don't have access to state support necessary, like healthcare, etc., without the employer's support. So that's the kind of vulnerability in the migration process. A huge facet for exploitation and vulnerability is wages. That includes both wage theft, wage delays, wage siphoning. Wage delays is said to be a big problem. People not being paid for months because the employer is not paying. I think a lot of us who worked in the Middle East are sometimes surprised by how patient contractors can be in terms of getting paid, particularly around the UAE recession. But what that means is, when we look at it in terms of, we sat in arbitration looking at what it means to a critical path. But what that actually means is that if the main contractor is not getting paid, then the worker who's maybe 10 rungs down the chain is not getting paid for many, many months. And that is that would mean that they're effectively working for free. And that would on any definition bring them into the scope of forced labour or servitude or slavery. It's also siphoning, so there may be that the wages certified or the money certified for someone maybe further down in the chain is held onto by someone further up the chain, and so on. There's also a vulnerability, particularly as migrants. You're not living at home, so you're living essentially with the employer. You're often housed by the employer in temporary housing, either on the outskirts of the city or on the construction site itself. And these are almost carceral conditions. The entry and exit into the housing is controlled. There's cameras. If it's a remote site, you can't actually go anywhere. The transport is arranged by the employer. And one particular abuse that is often raised is that your identity documents are kept or can be kept by others. Particular problem in the UAE is the kafala system or the sponsorship system. So some of you are probably aware that in the region, with some exceptions, to work or to start a business, you need a local person as a sponsor, and you pay them a sponsorship fee. It's a way of giving money to citizens. But it's a little more than that. In many jurisdictions, still recently, workers needed their sponsors' permission to transfer jobs and even to leave the country. And leaving the job without permission would lead to termination of the worker's legal status and could even lead to imprisonment. And that comes very close to, forget the legal definitions, what we understand as slavery, being put in prison for leaving a job. Largely as a result of civil society and media coverage, there have been moves to reforming the kafala system. It's not been abolished, and doesn't seem to be any signs of that. But in September 2020, with the FIFA World Cup in Qatar coming under the spotlight, and I suspect partly because Qatar was isolated from the rest of the Gulf states because of the embargo, they did announce, to be fair, some changes to the kafala system, which included scrapping the need for an employer's permission before changing jobs, and they put in place a minimum wage set at 1,000 Qatari riyals a month, and penalties for withholding wages. Again, in November 2020, Saudi Arabia has announced reforms to the kafala system, which are not yet in place. So again, that remains to be seen. But again, unionization and collective bargaining power remain prohibited throughout the states, and there's a very real imbalance between nationals and migrants in the legal and regulatory system. Subcontracting is, as I've said before, a huge issue, and however long the chain is, the fact is that the construction workers are at the bottom of that chain. the ILO report referred to just a standard practice for employers to withhold the migrants' first few months of wages, especially when labour was scarce, to ensure that they didn't abscond illegally to another employer. Often during times of financial difficulty, the employer will simply renegotiate costs with contractors and subcontractors, and that just leaves very little money to spare for the due wages. There was also a report that talked about quite a lucrative, well, not lucrative, but quite an important end of service benefit. So under the labour laws of Saudi Arabia, the UAE and Qatar, workers are entitled to an end of service benefit that accrues every year you work. But what that means is that if you leave before your end of service term, you forego that benefit. So the workers become vulnerable to saying, well, I've taken this exploitation for X amount of time. At least I have a chance if I stick it out another year to eventually get my end of service payment. COVID has clearly not helped matters. In March 2020, as a start to COVID, the UAE Ministry of Human Resources passed a resolution which allowed private sector companies to take certain steps, but only for migrant workers, not for nationals. Under Article 2, employers, with the consent of their employees, can put employees on unpaid leave, reduce their wages on a temporary basis, or reduce their wages on a permanent basis. I haven't put in the report from Equidem, which I recommend as reading, but the fact is that the consent was often obtained, certainly on their accounts, first-hand accounts with workers, by getting them to sign documents in Arabic, a language they don't speak, and often after physical abuse. So just I've put in some quotes. Our research documented cases involving thousands of workers who were left to starve without any pay and unable to return to their countries of origin. In some cases, companies took the dual step of making workers sign agreements without their consent to terminate contracts and send them back to their country of origin while keeping other workers employed without paying them. And again, I've put here some common forms of forced labour, confiscation of passports and identity papers, controlling freedom of movement, isolation, debt bondage, not paying, and threatening behaviour. I've also included an example of exploitation in the UK. Just conscious of the time, so I'll move on from that. Just looking at some of the main problems: recruitment fees, wage inequities, and poor benefits and poor conditions. What's the way forward? A useful source of the United Nations Guiding Principles on Business and Human Rights, the UNGP, which I certainly wasn't aware of till recently, but they're very well adopted, respected, and they were issued in June 2011. There are three key principles, namely they require the states to protect against human rights abuses by third parties, corporate responsibility to respect human rights, and the requirement for both states and companies to allow access to effective remedies for victims of business-related human rights transgressions. But this is a voluntary code. There's no international court or treaty enforcing this. There's also the Dhaka principles for migration with dignity, which, again, I'll leave the image here on the slides, but they talk about 10 key things to kind of look at in ensuring worker welfare. One thing that I think is of interest to us as construction lawyers, and it was in the BSR report, is a possibility of a building contract standard or more standards in terms of bidding documents, so that there's just a level playing field where worker welfare is a baseline. And what they found from interviewing some of the key market players was most interviews agree that including specific clauses on workers' rights in the bidding process has very positive impacts. Such clauses not only promote a level playing field among companies that benefits the workers involved in the projects, but they also make the implementation of workers' rights much easier. Included in the tenders, clauses on workers' rights ultimately form part of the contract requirements that are closely monitored by the client. In recent years, very tangible impacts have resulted from the incorporation of such requirements on worker accommodations. The same could be true with other issues, such as the payment of fees during the recruitment process, the retention of identity papers, or the on-time payment of wages, in particular within the subcontracted chain. The Modern Slavery Act 2015, the relevant section is Section 54, Transparency in Supply Chains. It's a bit of a damp squib. It basically says that companies that have a turnover of over 36 million must issue a slavery and human trafficking statement for each financial year. This may or should aim to include certain information. But it's entirely a model of self-regulation. It doesn't contain any penalties for non-compliance, nor is there any basis for looking at the adequacy of that yearly statement. I think the concept is that the publicity of a statement will make these big companies act on their own accord. There are moves for reform, and one that I found very interesting was a report by the British Institute of International Comparative Law called "A UK Failure to Prevent Mechanism for Corporate Human Rights Harms." And what the BICL is proposing is that there is a human rights equivalent to the UK Bribery Act, which means that it mandates that companies are mandated to undertake due diligence to prevent human rights abuses in their supply chain. And the recommendation is for this to have extraterritorial effect. I personally think that this is quite a useful and ambitious framework. Again, going back to that radical imagination, as you guys are aware, as you people are aware, the UK Bribery Act applies extraterritorially, and it asks companies to undertake due diligence to take reasonable steps to ensure there is no bribery in their supply chain. They have a defense of reasonable steps, but they have to make good effort, and it applies globally. And they came up with the BICL model comes up with a model clause which follows the Bribery Act, and I thought that was quite an ambitious and possibly useful step forward. Conscious of the time, I was going to talk a little more about this, but I'll just leave you with the headlines. This is a way forward. Again, this is about collaboration, about thinking about ways to face the problems. A big part of this will be civil society and the media, and we've seen the changes that have been affected in Qatar and the Gulf have come through media reporting overseas, and pressure on FIFA and pressure on client bodies. The construction industry, there does seem to be fair, good appetite in the construction industry to work on this, certainly for the big players, if it doesn't hurt them. So it has to be a collaborative process where they don't lose a competitive advantage by working on welfare. And this is not entirely altruistic. I think they are well aware that this is becoming a prominent part of expectations of their consumers. Legal and statutory reform, that, for example, this kind of twin of the Bribery Act that I mentioned. But most importantly, I think what I found most effective in the reading I've done in preparing this talk is actually learning from the migrant workers themselves, speaking to them, understanding their stories, understanding what it is that can help them. And there are many quite good organizations, well, not quite, but fantastic organizations working on this. And I think it's very important to incorporate their work.